Business Hour on OFM.
It's the Business Hour on OFM, the sound of your life, and I'm Lebogang Motsi. Copyright in South Africa appears to be in stasis. This is, of course, down to the concerns that have been expressed about proposed changes to the Copyright Act of 1978 and the Performers Protection Act of 1967. To explain the importance of being aware of what intellectual property assets are and monetizing them, we're sitting down with the Director of Intellectual Property at ENS Africa, Waldo Steyn. Good evening, Waldo. What exactly are copyrights and how does it work in the corporate and business environment?
Copyrights refer to a type of intellectual property, and it's a type of right that's created by an act like a patent or a trademark or a design or a plant breeder's rights. If you think about copyrights, you should think of it as almost as a bundle of rights that relate to original works of authorship. So things like artistic works or literary works, books, poems, films, musical recordings, and very importantly, computer programs. The great thing about copyright is that the rights come into existence automatically upon creation of that original work. But there's no formal registration process that's required to acquire the right. This bundle of rights include, for example, the right to copy a work or to make adaptations of a work and even to publish the work if it hasn't been published yet. As for how these rights work in a business kind of environment, copyrights are relevant to all businesses in some form. And the reason for that is, of course, it relates to so many different types of works. So, for example, if you think about a logo or marketing material, product design, software, data tables, photographs, music and film, all of these different things, these are all relevant to business in some way potentially. And copyright underpins the use and the ownership of the rights in those types of works. What is important for businesses is to understand how these rights are created and how they can own them. So, for example, if you are a business and you employ someone, then the Copyright Act provides that anything that employee creates in the course of his employment, the copyright in that work will be owned by the employer in the first instance. So there's no transfer of the rights actually necessary. Conversely, though, if a business would contract with a third party, so let's say it's a consultant, and they engage the consultant to create something for them, let's say it's the logo of the company or piece of software, then even if the company who commissions that work pays for the work, it doesn't automatically become the owner of the copyright in that work. There's got to be a written assignment agreement that must be signed by the creator of the work in order to transfer those rights. I think the first point is it's something that's definitely relevant to pretty much all businesses. And the second thing is it's relevant for the business to understand how these rights come into existence and how they can actually own them.
Waldo, what are some of the major differences between copywriting laws in South Africa as compared to other countries and the first world like the United States, etc.?
I won't go into too much detail on the question, but it's important to appreciate that as far as intellectual property laws generally are concerned, there's a large degree of similarity in the different national laws as a result of international intellectual property treaties. So treaties like the Berne Convention for the protection of certain copyright and the Agreement on the Trade-related Aspects of Intellectual Property Rights. So these treaties create certain obligations for members of that treaty or signatories to the treaty to implement similar legislation or rules in their local legislation. So there is this, let's say, a large level of uniformity in the way intellectual property rights are treated by different countries. However, there are some differences in these laws in the different countries. And this could, for example, relate to who can own copyright, how these rights come into existence, the treatment of ownership of the rights, how you can license it, and even how you enforce it. What we've seen with, for example, the US, quite often with clients, I get clients who talk about this idea of works made for hire, thinking that if you commission a third party to create something for you, such as a piece of software, for example, then you would automatically own those rights. South Africa doesn't have a rule like that. So the number of these commissioned type of works where the commissioning party in South Africa would become the first owner are really isolated. I can count them on the one hand. It's like if you commission someone to take a photograph, if you commission someone to make a sound recording or a film and you pay for that, then in South Africa you become the owner of the copyright in those works. But in the US, the concept is slightly wider than that. Then another sort of level of difference is something like the registration of copyrights. I did say the rights, you don't need to register copyright for it to come into existence. But what I find with clients in the US is that they record or effectively register existing copyright in order to use that registration in litigation proceedings, so where they want to enforce those rights. So some jurisdictions have little sort of differences like that, but there is really a large degree of similarity. But it is important that when you are, as a South African citizen, want to enforce a copyright somewhere else, that you understand the local laws, which will determine how you will enforce those rights and use them in a different country.
In closing, Waldo, what are some of the economic implications of not dealing with copyright concerns in the corporate and business environment?
There was a study done from the early 1970s to the late 1990s on the S&P 500 companies. And the study found that the value of intangible assets as compared to the total value of these companies rose from just about sort of or above 10% in the early 1970s to approximately 90% by the late 1990s. So what this shows is the significant value of intellectual property, of which copyright forms a part, in businesses today. So copyright is one of the categories of intellectual property assets, and the economic implication of not dealing with copyright, perhaps not recognizing the value of these rights, is missing out on key opportunities to create and recognize value in a business. So allow me to give you a practical example. A client of ours worked with an external company on the development of a piece of software for use in a sensor to be used in a certain Internet of Things device. Remember, software is a type of work in which copyright exists. So once the work was completed, our client wanted to protect the intellectual property in the software, only to learn that, one, it did not own the copyright in the software, and two, the developer was already in discussions with a party in South America to license the software to it. So an asset created on the initiative of our client, and the creation of which was actually funded by a client, was owned by a third party, lawfully. There's nothing unlawful about this. So not understanding the value of intellectual property, and specifically copyright, in a business cost this client a significant commercial opportunity and deprived it of a very valuable asset.
That was my conversation with the Director of Intellectual Property at ENS Africa, Waldo Steyn. He was explaining what copyrights are in the grander scheme of the intellectual property world, how there is great uniformity across countries in terms of intellectual property regulations with slight differences that we need to be conscious of, and the significance of investing in your company's copyright. Now, if you missed this conversation, you can catch it on the business blog on ofm.co.za.
The Business Hour on OFM.